In fact, such a letter is as useless as an identity card without a picture of the person who is being identified. Without a national ID, without a passport, without any sort of identification, I hope we are secure. What is that?
What's that register?
Why is it?
Why is it behind the No, exactly.
When you would want to know the contents of that bag?
Prisons, what are the contents of that bag?
You came with this from prison.
So why is he choosing to keep it behind that?
I gave it to you. It's nothing.
Then let him sit with it or put it outside already. Prisons can you just take possession of that?
That bag is not Counsel. It's not representing the application. You take it back there, you take it. Your Worship, there is no, without a national ID, without any form of identification, and a blind introduction letter from the LC leaves this application in the top of Pagamaya. Because we need to understand who the applicant is, away from what he presents himself to. As if that's not enough, in the same letter where the applicant was introduced, it does not reflect anywhere that he has a fixed place of abode. Something that would probably act as a fallback for this court, given that he doesn't have any identification, the letter does not have his picture. Because you can't guarantee the only Mabirizi. There are so many Mabirizi. And Mare. The issue of a fixed place of abode is critical because it guarantees abode is important because then it instills trust and confidence in the judicial officer that the person they are about admit on bail are traceable. Otherwise, you might be a nomad in terms of movement from one village to another. You rent here for 1 month, you go to another place for 1 month. Now, how it becomes a problem for us to go running back with such a person in case he was supposed to bail. We might go to find that that is the effect of this application, and that ground failed. The applicant, in addition to that, in the hope of introducing himself, presented himself as a person who is a civil rights activist. Your Worship, there is no proof to show that it is a civil rights activist. A civil rights activist is attached to a particular organization, which is normally a government organization, which has a legal foundation or a legal basis. merely volunteering every morning to do what pleases you does not make you a civil rights activist. It was some cosmetics meant to turn a black person into brown. But when you remove that cosmetic, the person goes to his original state. And this is what Mabirizi did. Further, the antecedents of the applicant add salt to his wound in this application. The applicant is a convict. Is an ex-convict, even served in Rosera for more than a year. Your Worship, in the bail guidelines cited under paragraph 13, 1C, court is supposed to take into account the antecedents of the applicant. If his history is tainted, it is dented, then who are we to sanitize it and say he's the right person and therefore he's worth it? Admit him on bail. The antecedent speaks to so many things. One, that is not a law-abiding citizen. Yes. One, that is not a law-abiding citizen. Two, that you will actually reoffend if released on bail. And the possibilities, Your Worship, of reoffending if released on bail are so high. And we invite this court to agree with the prosecution in that regard. And if our request is answered in the affirmative, then it will be a huge risk admit this applicant on bail. So it will be a huge risk, Your Worship, to consider or to admit the applicant on bail. The applicant presented himself, painted a picture as a person who is so useful to the community by referring to so many references. Mabirizi versus Attorney General coming up today, African Court of Justice, blah blah. It's not. Because the references, these references or petitions that he actually cited have no impact at all in the justice sector. They have no impact at all. In citing these cases, Your Worship, in fact, they are a very good ground for why this court shouldn't admit him on bail. if the applicant is allowed to travel to beyond our borders, the possibility of him returning are minimal. I refer to these references, Your Worship. I may not repeat them, but he was citing how they are before the East African Court of Justice. And to attend to this, he has to travel there. It's alleged, Your Worship, that the applicant doesn't have a passport. It came up. This alone is a sense of irresponsibility. It is a sign of being an irresponsible citizen. You cannot hold out as an international litigant, but again, you don't have a passport to move from one place to another. That is one. Why does that show? That the applicant uses his national ID to travel. Uses his national ID to travel, of course with the beautiful East African Corporation. Which he has not furnished. And it is not anyone with any of the security agencies. Isn't that a risk? I should invite this court to find that it is possible the applicant is finding a way through this application to escape justice.
What happened was a civil contempt of court order. Which is not criminal in nature. And with this, I will refer you to the Supreme Court. Consolidated civil applications number 25 and 26.
Supreme Court?
Yes. Civil applications number 25 and 26 of 2020.
Number?
25 and 26 of 2020. It is called Bet Kizito versus Kanonya, Kanon and others. The Supreme Court held that contempt in disregarding orders or judgments of the civil court is not criminal in nature. Orders or judgments of the civil court is not criminal in nature.
It's deceptive in terms of the passport. If it is not being deceptive, it's irresponsible. Since this application requires the applicant to be very well introduced before this court, and the applicant failed, we this court to find that it doesn't merit being admitted on bail. Your Worship, the possibilities of the applicant absconding bail are very high. Why is a flight risk?
I rely on an authority you have already. That is Mabirizi versus Uganda. High Court Criminal Application 83 of 2016. At page 12, Justice.
The number is 33.
Yes. It is, no, 83. Criminal Application 83 of 2016. Page 12, Justice Masalo Hussein. The last paragraph. Saying that on the issue of defiance campaigns, which Counsel for State submitted on, I hasten to state that the issue of defiance campaign is now sub judice. It is pending in the Constitutional Court, and this court cannot comment on the same.
Mr. Chibazo Nasa, Your Worship, is an advocate attached to Chibazo and the company Chibazo Associated Advocates. Your Worship, amongst the documents on record, I would refer you to the forwarding letter which Chibazo Advocates wrote to this court dated 9th of February 2026. I have a copy. Your Worship, I believe there should be a copy on the court record dated on the 9th of February 2026. This letter was forwarding letters and supporting documents for the accused and his sureties. It cannot be at the same time that a lawyer, Mr. Chibazo, who first appeared the day when the applicant appeared in court for plea, turns out to be a surety of the applicant. Mr. Chibazo appeared and is on record on the very first day for plea taking. That is unprofessional. In fact, it has so many things. It's unprofessional, uncourteous, and being disrespectful to his court. For an advocate who has appeared and is on record for representing the applicant, I mean an accused person or applicant for that matter, to go and address himself again as a surety for the applicant. This is the first time I'm seeing this. This is complete conflict of interest. And Your Worship, if alone going on record for being counsel for the applicant, even if Mr. Chibazo had not been put on record as a counsel for the applicant, but the fact that he's a partner with Chibazo Associated Advocates makes him ineligible. It is not ethically not ethically fine for him to start